Okay,
I don't know if you can hear me, but I heard you and then you went out.
but I
I
got
can't
audio.
back. I can hear you.
It might be his AirPod.
Can you guys hear me?
Now I can, yes. Can you
Okay.
hear?
None of the town hall audio is coming through on my end.
Great.
Check 1, 2. Check 1, 2.
I can see you guys, but no audio.
I thought
I
you
can
just
hear fine at our end.
Steph said she could hear.
Stephanie?
You might have to put it in chat.
Volume's all the way up.
I'd have to select a different audio option on Zoom. Because it's Stephanie there. It's him.
Yeah, I think it might be his AirPods.
So you still can't hear us, Rob?
How do we tell him if he can't hear
In
us?
chat. No, he can type a chat.
You can?
Yeah. I would do that. I think he needs to switch the audio setting on his computer.
You might be on mute.
Do we have his phone number?
Can you type in the chat function?
I'll take his earbuds out.
Yeah.
Does Stephanie hear us?
Bueller?
Hold up a piece of paper. What's your phone number?
Yeah.
If he was on mute, we wouldn't be able to hear him.
He can't hear us anyway, our chairman.
Do you,
Take your earbuds out.
anybody comments?
We don't have his number.
Could we write in the chat?
I think it's your earbuds.
You think it's?
You guys can hear me, I can't hear you.
Yes.
Can you write in the chat?
Oh, wait.
Find the vital stuff to write it. It's just like speakerphone.
Do you want me to go email him? I think I have an email.
Can we just chat?
Is there no chat feature?
Yeah, I don't
Is
think
it under more?
No, it doesn't work.
Yeah, I don't think there's.
Wait, where's the picture? We'll
You can
send
hold up
him
a
a
phone
note.
number, yeah, yeah,
No,
yeah.
no, no.
I mean, hold up a piece of paper that
I'm gonna
says.
hold up a piece of paper.
He has an idea. He's got it. Yeah, take your earbuds out.
I just texted him, I think.
Okay, where do I
Yeah,
hold this up?
I got it, we're good.
Okay,
Yeah.
great.
You have a charge of
Technical difficulty all time.
His phone.
And the lawyer's he's almost here, I'm just the town attorney, I'm just gonna leave the hall to show him where to go.
Okay,
He should be here in a minute.
okay.
Madam Selectman, there's some other business we can.
Yeah, I would start, although it's not my business, so.
He's the chairman, right?
Yeah.
Okay,
Currently.
Why don't you open the meeting?
I
We
can
have
hear
four-
you guys now.
Okay, good. Why don't you open the meeting? And we have 4
Okay.
items on the agenda, some business.
Yep. So time is currently 7:05, so I'd like to call this meeting to order. Do we have 1 second? So can we have roll call of current members here? I'll start. Robert Huxley, current chairman.
Cynthia Macula, member.
Marie Polito, member.
Mark Stricker, vice chair.
Nick Polmus, member.
Dan Stutzky, alternate.
Okay, so it appears that we have a quorum of current members. So I believe that we are all set to proceed. So we have a quorum. Since this is our first meeting since the election, I asked town council to be here to speak to newer members regarding some things. I don't know if we would like to do that before we determine officers, or if we would like to determine officers first.
Probably your purview.
Okay, if we're going to elect our current officers first, we can open for nominations. I would like to nominate Mark Stricker as chair.
Second.
Okay. All in favor?
Aye.
Aye. Any nays? Any abstentions? No? Okay. Do we have nominations for vice chair or for co-chair?
Yeah, you.
Okay, so for the record, Nick, you're nominating me?
I am.
I'll
Okay.
second
Do we have a
the-
second?
Mark Stricker.
Okay. All in favor?
Aye.
Aye.
Aye. Any nays? Any abstentions? So it passes. Congratulations, Mark. It's your board.
I guess I'll take it from here. Thank you, Rob. All right, so our first order of business is now to approve the 2026-2027 monthly meeting calendar. There's a copy in front of us, and you were sent in the email. So do we have any nominations to approve that? Or do we have any discussion on that before we?
I'll make a motion to approve it.
I'll second.
Nick seconds. In favor, yay?
Aye.
So that passes. Okay. Monthly meeting calendar has been approved for this coming year. And then we have the approval of minutes from January 13th, 2025. Hopefully people had a chance to review those. Any motions to approve minutes?
Motion.
Approval.
Second.
All right. Nick made a motion to approve the minutes. Cynthia seconded. Vote to approve the minutes. Aye.
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 And then, I guess for the record, you would abstain, or you would abstain, since she wasn't here for the last meeting, or on the board. Okay. And then Rob had mentioned that you wanted to, were you gonna say a few words to the board, or?
No, I
Okay.
think you should proceed with your agenda.
Okay.
We do have a training session that's been scheduled for the first week
I
of
think,
March.
March 2nd.
Yeah, our first selectman, Carol Goldberg, is here. If no one has any objections, she just wanted to make a couple announcements for our benefit in terms of some trainings and things coming up.
Thank you. For the record, Carol Goldberg. I just wanted to invite you to two events that we're having. One is on March 2nd, Attorney DiCrescenzo is going to come talk to Planning and Zoning and Zoning Board of Appeals. It's at 6:30. For now, it'll be in the Selectmen's Conference Room. It's really to go over both boards, what you do, how you do it, running a meeting, things like that, things that are really critical, especially for a lot of new people. I know a lot of you are not new, but there are people who are new on other boards. So I really invite you to come. I'm really going to ask you to come. I think it would be really important. The other is on March 19th, we're having a training. Someone from the Freedom of Information Commission is coming, and we have a training that's going to be twofold. One is at 3 o'clock in the afternoon, and the other is at 6. So the 3 o'clock one, so Freedom of Information basically, I'm simplifying, but talks about records and record keeping, and the other talks about how to run a meeting, and it's a little bit of both. So at 3 o'clock, the thought was to have town hall staff come in case they get any Freedom of Information requests, but you're all welcome to that as well. And if you can't make it, or they can't make it, or also he's gonna stay and discuss Freedom of Information at 6 o'clock. Presumably at 6 o'clock, he'll talk more about running a meeting, but he's going to be talking a little bit about record keeping in case people can't make either one. So I invite you to both of them, and I encourage you to come. Thank you for the time.
Thank you. Okay. So I will now, the time is 7:12. We'll open the public hearing, and I'll read the notice. For the record, the Zoning Board of Appeals of the Town of Bethany will hold a public hearing on Monday, February 9th at 7 p.m. in the Commission Meeting Room of Bethany Town Hall to hear the application by Robert Marinko Sr. and Lori Marinko appealing the decision of Zoning Enforcement Officer regarding the property owned by Hopbrook Storage located at 43 to 51 Russell Road. The foregoing application file is available for review during regular business hours in the Land Use Department at Bethany Town Hall. The public is invited to attend and be heard.
Mr. Chairman?
Yes.
For the record, and to enter it, there's a copy of the legal notice as it appeared in the New Haven Register on, you could read that better than I.
January 26, 2026 and February 2nd, 2026.
And also, as required, the applicant must send certified letters and have it certified. And this is a copy of what was sent to each of these addressees, and here is the receipt as part of the record.
Okay, thank you. So entered into the record. All right, so the public hearing is now open. Would the applicants like to make a statement, or someone on their behalf?
Sure, thank you.
Okay, please state your name and address.
Borrow this chair as a
Sure.
addressing spot.
Yes.
Good evening, all. My name is Attorney Timothy Lee. I have an address 107 Monowee Street in Branford. I'm here tonight on behalf of Robert Marinko and Lori Marinko. Robert Marinko Sr. is an abutting property owner to the property at 43-51 that was referenced in the notice. We have appealed a decision of the zoning enforcement officer issuing an administrative permit for the property at 43-51 Russell Street. And just so the record is complete, I'll submit a copy of the permit itself, so that's part of the record. My client had also submitted numerous other documents to the zoning enforcement officer during the lead up to tonight's hearing. I just want to make sure that those documents are also part of the record as well. Thank you.
Yep.
So by way of background, as I mentioned, Mr. Marinko Sr. Owns property which abuts the property at 43-51 Russell. Hopbrook Storage is the owner of that property. They had submitted an application to the Planning and Zoning Commission to create a third building on the property. My client attended all of the planning and zoning meetings regarding that particular application and filed a petition for intervention under 22A-19 to be able to participate in the hearing before the Planning and Zoning Commission, even though the application was not a public hearing itself. The application spanned over 3 or 4 months without much substantive discussion regarding the application. On the last night of the hearing, the Planning and Zoning Commission said, hey, we don't know what to do with this application. We don't know what to do with the petition for intervention filed by Mrs. Marinko. So we're just not going to take action on the application, and the application is going to get approved by operation of law. Under the law, you have a certain amount of time to act on a site plan application. If you don't act upon that site plan application, planning and zoning doesn't act on that site plan application, the application gets approved as a matter of law. So in this case, the Planning and Zoning Commission opted to take no action on the application. I think that's dereliction of their duties as Planning and Zoning Commission, but they did that. We have appealed that decision to the Superior Court. That appeal is pending. In the interim, the owner of Hopbrook submitted the administrative zoning permit to the zoning enforcement officer in order to get a building permit to start construction, and construction has in fact started at the property. We appealed the decision of the zoning enforcement officer because we think the issuance of the administrative zoning permit is in error. And we believe it's an error for a number of reasons. First, under the zoning regulations, if you have 3 or more buildings on a property, that property is considered to be, let me just get my zoning regulations out. Yeah, I was just going to pass out the handouts as we go. Under the zoning regulations, the properties in the business and industrial, the BI zone. The BI zone does allow certain commercial uses in that zone, but if you have 3 or more buildings, it's considered a business park. And in order to have a business park on the property, you need to submit a special permit application. So we believe that the zoning enforcement officer erred in approving the zoning permit for the construction of the 3rd building, because that 3rd building created a business park. The business park is a special permit use under your zoning regulations. Because it is a special permit use, that use is not entitled to inferred or automatic approval. That's the difference between the site plan use and the special permit use, and therefore the zoning enforcement officer should not have issued the permit. During the course of the application before planning and zoning, we had raised the issue to planning and zoning that the application was incomplete. And one of the reasons we said the application was incomplete was because the owner of the property did not submit a statement of use. They want to build a building, what is that building going to be used for? Ultimately, the applicant submitted a statement of use saying the property was going to be used by Verstag manufacturers. They also have an address, a facility at that property, and he was building this addition in order to allow Verstag to expand their operations to a new building. My client, Lori Marinko, has been in contact with the Verstags. Emily Verstag is on the call tonight. My understanding from the conversation is that Verstag has no intention of occupying that third building. They did not authorize the applicant to submit an application for the third building, and they are not going to move into that building. So now we have a problem that we have a third building, which is going to be a third use, creating the business park, which requires a special permit, which therefore the zoning permit was issued in error in that case. Second reason we appeal the decision is because, and for those of you who have been to the site, you can see it's an active construction site. Under the Bethany zoning regulations, if an individual does more than 5,000 square feet of earthwork on the property, that requires a special permit. Special permit requires an application to the Planning and Zoning Commission, requires the Planning and Zoning Commission to hold a public hearing at which members of the public can speak on the application. Planning and Zoning did not require the applicant to submit a special permit application. There was no public hearing at Planning and Zoning, but lo and behold, now that the zoning permit has been issued, there is a ton of site activity going on at the property. My client had submitted a letter to the zoning enforcement officer with a number of photographs. I'm going to submit those photographs for the record. Third issue for the appeal is that our understanding is that the property owner wants to conduct self-storage. This whole application was, in effect, a ruse to get a building in order to create a self-storage facility. You know that the Verstags are not interested in this property, so what is the use of the property going to be? And if it is a self-storage facility, self-storage facilities are currently under a moratorium by the Planning and Zoning Commission. Planning and Zoning cannot approve new self-storage facilities, and the zoning enforcement officer cannot issue an administrative zoning permit to allow the use of the property as self-storage. So based on the fact that our understanding is Verstag's not going to move into the property, there's no particular use for this property, the applicant had decided, earlier referenced the fact that we're going to do self-storage. This is a self-storage in a Trojan horse to get self-storage there. Self-storage is subject to the moratorium. Because it's subject to the moratorium, it was not an appropriate subject matter for the administrative zoning permit. If the commission agrees that the zoning enforcement officer should not have issued an administrative zoning permit, the zoning enforcement officer should stop the activity that is currently going on site, should stop the earthwork, the grading, the excavating, the filling, which all exceeds 500 square feet, and they should make the applicant come to the Planning and Zoning Commission. They should make the applicant come to the Planning and Zoning Commission to submit a special permit for the fill and excavation under the Bethany zoning regulations, and they should require the applicant to submit a special permit for a business development park under the Bethany zoning regulations because the site now has 3 or more buildings. Planning and Zoning will have a public hearing. My clients will get the opportunity to participate in the public hearing. Other members of the public will get an opportunity to participate in the public hearing. And the Planning and Zoning Commission can then make an informed decision as to what exactly is going on at the property, what is the intention of the applicant, how will the property be used. And then Planning and Zoning can render an informed decision. But right now, the way things happen with Planning and Zoning on the site plan application, that there's just very little knowledge as to what the use was going to be. We think the use was not represented correctly to the Planning and Zoning Commission, and therefore, based on the totality of circumstances, we believe that the zoning enforcement officer erred in issuing the administrative permit to ultimately allow the property to be developed in this manner. In addition to those 3 major points, my client did submit a letter to the Zoning Board of Appeals dated January 7th. In that letter, they raised a number of other bases for the appeal, including the fact that it's a business center, there's a moratorium, and that the fill and excavation. In addition, they raised a number of other issues As you can see from the photographs, there is site work that is going on at the property. There is earthwork, there is excavation. Has that stuff been viewed by inland wetlands? Before you submit an application to Planning and Zoning Commission, you have to submit an application to inland wetlands. I don't think inland wetlands was ever informed that this level of site work was going to occur on that property without a decision from the Inland Wetlands Commission regarding the level of site work and the activities going on there. Planning and Zoning should not have approved the application, and certainly the zoning enforcement officer should not have issued an administrative permit to allow the construction to go forward. In addition to that, my client's letter references a number of other issues. The site plan application, the application which was subject to the administrative permit, is incomplete in a lot of manners. It has inadequate parking and loading. The new building does not show any parking or loading spaces. Presumably it was going to be used by Bear Stag, but if Bear Stag's not going to use the property, how are people going to park there? How are fire going to access the property? And how are employees, or whatever the use may be, going to get into the property and park their cars? Once again, the application is incomplete and was raised at the Planning and Zoning Commission in terms of lack of stormwater management designs, lack of landscaping, lack of parking and loading requirements, lack of inland wetlands approval, lack of fire plans, lack of storm drainage. So based on all of these circumstances, we believe that the zoning enforcement officer should not have issued the administrative permit. Activity on the site should be stopped. The applicant should be required to go to planning and zoning, submit the appropriate special permit applications, special permit application for the fill and excavation, a special permit application for the business center, let planning and zoning have a hearing on the application, and let planning and zoning commission make an informed decision. So we are asking this particular board to uphold our appeal of the issuance of the administrative permit so that the zoning enforcement officer then can stop construction until the appropriate permits are issued for this site. Happy to try to answer questions if the board has any.
The fire marshal sign off on this?
I'll ask the zoning enforcement officer that question.
I don't have an answer.
So we'd have to reach out to the fire marshal to see if he approved this.
Regarding the number of buildings that are going to be on the property, are you counting both 43 and 51 together?
Well, so that actually raises another interesting question. Is it one property or is it two properties? So if 43 and 51 are considered one property, then yeah, our appeal includes one property. If 43 and 51 are considered two separate parcels, then you have a host of other issues because you have setback violations all over the properties. So that is one of the significant issues is it one property or is it two properties? And quite frankly, from the Hopbrook storage, it has to be one property because otherwise, from a purely zoning perspective, they would need all kinds of variances in order to have those two buildings. That being said, if it is a one building, it is considered to be, if it's one property with three buildings, under the regulations, it is considered to be a business park, which is a special permit use in this particular district.
Okay, I just wanted clarification on the record for that matter, so thank you. One other question, also just for the digital record here. That particular area along Amity Road, within a certain distance of Amity Road, is not, I don't know the exact language of it, but it is considered B&I along that area. And there is mixed residential in there. I know in one of Mrs. Marinko's letters, she had said this is a residential area. So that property isn't I just wanted to clarify that property isn't necessarily residential. It could be B&I. That doesn't make any of the other issues potentially okay or not okay. I just wanted to put that on the record.
Fair. My understanding is that the particular property we're discussing tonight is in the B&I zone.
Okay.
There may be residential properties around it, but the 43-51 is in the B&I zone.
Okay.
So I had read in the minutes of planning and zoning
Yep.
that the Inland Wetlands Commission had declined, didn't think that they needed to have an opinion or give approval or not.
So I think that's part of the problem, is that I don't think Inland Wetlands was ever advised that that level of site activity what's going on. I think if wetlands knew, if planning and zoning knew that that amount of earth material was going to be happening that site, I think then Inland Wetlands probably would have viewed it differently, and planning and zoning would have viewed it differently. So that's why we want to submit the photographs that my client had taken over the last couple of weeks, showing that the level of site roof is.
Wait, Cory Marinko, can I speak on inland wetlands?
I'm gonna call you up to speak in a moment.
Thank you, please.
Did you guys want to see the photos? Do I need to hold these up for the camera at all, or?
They're part of the record. If someone in the audience wants to see them,
Okay.
I think we can accommodate them.
Before I turn it over to Ms. Marinko to address the boards, do you have any further questions for me? Laurie, I'm gonna have you come up and.
Hi, for the record, Lori Marinko, 21 Colville Road. I just want to say, first of all, we've been treated very badly. I really believe we've been treated very badly. The first thing I want to go over, in this letter that you have in front of you, the business center and development, that is absolutely a business center, which means he has to have that entire complex up to date. He's got to have draining and landscaping and parking and everything that goes along with a business complex he has to have. He can't just add one little building and assume that it's a go-ahead. It's in the laws, it's in our regulations, it's a business center. The entire complex needs to be done. There is a local drainage basin underneath that property that nobody has ever mentioned. Their engineer never mentioned it, but there is a local drainage basin underneath that property. And that water underneath that property drains into Long Island Sound. Nobody has ever mentioned that. Their engineer swept it under the rug. No, absolutely nothing about that. And according to the DEEP, you have to have the DEP approval on that. You just can't go build, you can't just go build like that. You have to have the DEP look at that and say, okay, you could build on that. Plain and simple. They can't just go in there at their leisure and build. Did anybody ever look at the QVHD permit?
Is it in this?
Yep,
packet?
next page. That right there knocks us dead. He can only have 5 people on that site. 5 people on that site. That should knock it dead. If
For
you're
which
gonna
property,
risk,
43 or 51?
51. He can't have more than 5 people on that property according to QVHD. That right
But there
there
is no
should
restriction
knock
on
us
the other
dead.
property.
I'm sorry?
But there is no restriction on the other property. You're only noting 51 as the property that has the restriction, not the
Right,
other property.
43,
Okay.
right, 43 hasn't been touched since, I don't know, the 80s, at least. I have no idea, but I know there is no drainage at all on the entire 51. It was in the engineer's report. So that's that. And just so you know, it is a state law that CGS 22A-427 states, polluting or risking the pollution of groundwater and surface waters is a serious environmental offense, and a 5-person permit violated that law. So right there, that's against the law. The moratorium, this is a storage building. It is 1,000,000% a storage building. He submitted everything to Inland Wetlands as a storage building, 100%. And then they find out about the storage building and they go change the description just to bypass this moratorium. If you look on that letter that I sent, the Griegers have 11 storage buildings in town. It's just another storage building, and he's doing this just to bypass the moratorium. Parking and loading, I've sat at these meetings for the past year. Inland wetlands and planning and zoning, let me tell you, nobody has ever mentioned handicap parking, the number of parking spaces that need to go in there, loading dock, fire and emergency. Nobody has ever mentioned that. I mean, go back and look at those meetings. I mean, it's terrible that, here's these regulations, look at them, view them, obey them, and that's not been done at all. There's unsafe internal circulation and maneuvering in that property, fire access conflicts. There's no stormwater pollutant discharge in those parking areas. What about handicap parking? There's nothing at all saying that. And getting back to inland wetlands, when we went to all those inland wetlands meetings, we had to suffice but Christine Sullivan screaming her face off at us. For what reason, I don't know, but we couldn't even get a word in edgewise. The only reason why inland wetlands bypassed the application was because he took the building and he put it like way in the corner, so it was not in the inland review wetland area. But everything else that's being done up there, all of this, inland wetlands doesn't know about. This, inland wetlands doesn't know about. This is sandblasting. This is watering down metal pieces. Everything is being polluted into the wetlands. Everything that happens here, it's metal, it's sheet metal. It's what a harm to the environment. The same thing here, and I listed all the laws that are being broken on that property right now. So that's the only reason why he got past inland wetlands, because he did not tell them about all of this stuff. Didn't even mention it to them. And we said 2 parcels. There's a copy of the deed in here. It shows parcel 1 and parcel 2. So it's 2 parcels. And he is not abiding by the setback rules, and 2 parcels, not 1. The fire plan, there's no design package of fire. There's no calculations from a licensed fire protection engineer. Appendix 4 of the zoning regulations, Appendix 4 of those regulations right there, it states, the very first page, the owner shall provide the P&Z board the design documentation for water sources as part of the regular site plan approval. Absolutely nothing. Nothing from a licensed fire protection engineer, nothing from a water resource officer, nothing at all. There's no fire lanes, no hydrant locations. There's no provisions for a fire apparatus access or firefighting operations. There's absolutely nothing. And you know what? We live right there, right there. So if one little spark from those little classrooms that they have there, because, yeah, one little spark, that whole thing could go up in flames, because we just don't know. And of course, the landscaping is there with it too. Requires all commercial lots must provide a continuous landscaped area along all sides and rear lots. The applicant didn't comply. They only submitted plans for the area immediately surrounding their little building. And it's not a discretionary requirement. The missing items, materials sold and stored on the premises, outside activities. There are a ton, as you could see here, a ton of outside activities. And the client and the applicant did not put that on the site plan. Section 911A.3.A, the ZEO didn't know the widespread damage this proposed building may impact. because the applicant didn't submit the required general map showing the surrounding property within 500 feet. There's a daycare center and 14 residential properties within 500 feet of that proposed building, a daycare center. Living next door to that property is a New Haven policeman with his 3 little kids, all under the age of 5 years old. Their playground is right there. From here to maybe there, that's where these little kids are gonna be playing. And the most important thing, Bethany residents were never informed that the applicant was gonna put in this industrial metal manufacturer. Everyone was told it was a storage building back in 2024. Nobody has any clue that this is going to be, or prefabricated to be, Verstig Art Fabricators. And then I have a whole list of permit standards not in compliance. The other thing is Russell Road. Russell Road, does anybody know Russell Road? Russell
Very
Road?
well.
It's very curvy and windy. You can't see anything coming out of those driveways. You got 18-wheelers coming in and out of those driveways. You mean to tell me you got your pedestrians, you got your horseback riders, you got everybody walking down that street. You are not gonna see this big old ass 18-wheeler coming down that street. You can't, there is no sight line at all. Can't do it. I don't know why, for bonds, they never submitted any bonds. P&Z never asked them for bonds. There should be bonds there because, as you know, they exist to protect the town when approvals rely on promised future compliance, and that goes against CGS 8-26C.
I'm sorry, can I ask what town regulation you're referencing when you say handicap parking is required?
That's a federal law. That's a federal law.
Connecticut state law says total number of parking spaces 0 to 200. Number of special parking spaces required is exempt.
Exempt, so they don't have to have handicap parking?
Well,
They
handicap
are
parking is.
exempt. They're exempt from being required to have it.
So I'm not sure that I agree with that. Handicap parking is generally something that's regulated by the building department. So the building department will make a determination as to whether handicap parking spaces are required for this site or not. To Lori's point, there is no parking associated with this building, so the building department should require handicap parking spaces as a result of this application.
I just wanted to know if she had a town code number involved in that statement. That was all. Because if there's a town code, then respectfully, let me finish. If there is a town code number, then we can consider it. If you don't have a town code number involved with this statement, then it cannot be considered in our decision.
Well, it's all in my letter. It's okay, okay. Let's see, so the bonds, they need to have bonds, it wasn't done. The Bethany Plan of Conservation and Development, of course, that is just a document. That is not a regulation, they don't have to go by it 100%. But if you look at regulation 8.3.A.1, Bethany Town Regulation, it states, the proposed activity shall be compatible with the adopted plan of conservation and development. And it is also repeated in regulation 911C. The proposed development and use shall be in conformance with the purpose, intent, and policies of the Bethany POCD. This building does not go anywhere near the Bethany POCD. Local resident roads must not be burdened by intensive development, and that's what this is. So that goes against our Bethany POCD. The project ignores known infrastructure limits. The development places public safety at risk with air, soil, and water pollutants. Watersheds must be protected at all costs, and that is going back to page 3 of my letter, local drainage basins. They must be protected, and by building a metal structure on that land, that is not protecting. The Bethany POCD states rural life must be preserved. The size, volume, and scale of this development will destroy rural life, and that is in our Bethany POCD that has to be adhered to because of these regulations I stated. So now the drainage. If the applicant follows the site plan, the proposed drainage location is unreasonable and it is unfair because that detention system is only 20 feet from our property line, directly upslope of the neighboring driveway. Any failure, blockage, or lack of maintenance would result in runoff being discharged into neighboring properties. So if they don't keep that detention clean, it'll be our driveway that takes the hit and not theirs. In fact, our town engineer, David Naffis, expressly stated that the proposed drainage system requires modifications, including installation of inspection ports, written maintenance, and inspection schedules, and they never did that. And then the final paragraph I have is about stormwater management report by John Paul Garcia. You could go in there and see that no drainage basin, no analysis there. The infiltration is assumed and not proven. There's no valid pre-development baseline. The modeling ignores downstream and cumulative impacts. And the bottom line is, Garcia's report evaluates only parcel level flows under site conditions that no longer exist. It fails to analyze basin impacts, groundwater behavior, or cumulative effects. As a result, it does not provide stormwater analysis required to complete. Now, since he got the signatures and whatnot, he went in there and he created his own fill. Truckloads and truckloads every single day of fill. Section 8, he violates the entire Section 8 of Planning and Zoning Manual, the entire thing, because as you can see in this picture, look at the elevation that he created. That was the old one. This was the original elevation. 12 to 14 feet, he dumped fill. So whatever approvals he got from QVHD, from anybody you want to say, any engineer, it's out of the water now. It no longer exists. It's not relevant anymore. He's got to get everything done over because of what he did with all that fill. Who knows where that fill came from? We have no idea. And if you could see on the next one, you could see how he sloped it onto our driveway. Do you see the hill? You can see right, if I'm standing in my driveway. Yeah, so he's got everything coming down into our driveway. That was not on the site plan at all. The one other thing I want to say is, I want to thank Carol Goldberg for looking into the training of planning and zoning, because they are not trained. They're not up to date. Our Planning and Zoning Commission, they are not up to date. They don't have their training that they need. I have an FOIA with Mr. DiCrescenzo over here. I put it in about a month ago. I haven't had anything on it since to get the training of our planning and zoning officers, because I don't think they look at the regulations. I don't think they know the regulations because they are not trained. They're just random guys off the street with no training. So I want you to consider that. The other thing I want you to consider is, when we had that application, I had a CGS 22A19 on that. I have 3 lawyers in this for a 22A19. They denied me my right to speak. You can't do that. And that's why we're going to the Supreme Court on that. So when I say they treated us badly, they treated us badly.
Why did they deny you?
Because she didn't want to, because Nancy Held Sheehy did not want to set a precedence. She didn't want people to come forward and speak about environmental issues. And that's on tape. You could look at that yourself. It's on tape.
I
So,
thought it was because you're not one of the abutting neighbors.
Nope.
Your address is different.
Right.
You don't live on Russell Road.
So during the course of the application before planning and zoning, the application was submitted as a site plan application, which does not require a public hearing, so members of the public do not get a chance to address the commission. Ms. Marenko filed a petition pursuant to General Statute 22A-19, which allows her to raise environmental issues before the commission. Some of the issues she's raised before you tonight. If she submits the application and it's accepted by the commission, she becomes a party to the hearing, to the application, and she can make a presentation to the board. It's our position, and this is part of the appeals report, that the Planning and Zoning Commission denied her right. She had submitted a valid petition under 22A-19. She should have been made a party to the application. The Planning and Zoning Commission should have heard her testimony on these environmental issues, and the Planning and Zoning Commission made an error by not accepting her petition and by not allowing her to address the commission on those issues.
Thank you for clarifying.
I have one final point. Can I talk about the beer steak?
Please, ask us.
Okay, so I was out at my in-laws' driveway. I was approached by Emily Versteeg and her brother. They told me they did not give the Griegers permission to use their name. They did not give the Griegers permission to use their name. They do not want this building. They never had any intentions of moving into that building. They did not want their name used at all. So that shows me clear as day that the Griegers submitted falsified documents in order to get their building permit. And that, to me, last time I checked, is a criminal offense. And they told this to me directly. And that will go to court. That will go to court and criminal charges. I don't know what's happening with that, but you cannot falsify documents to a municipality in order to get your building permits, and that's what they did. I'm done.
One thing, let me say, irrespective of whether it's criminal or not, we'll let the police determine whether those representations were criminal or not. It's not up to the zoning board of appeals to determine that. However, it does go to the issue of whether this is a business center, because under your regulations, a business center is a planned development consisting of 3 or more businesses, commercial or industrial establishments on the same lot. So if there's self-storage, if there's Veristag, and then you have a third building which is not being used by Veristag, it's used by something else, it's either going to be self-storage, which violates the moratorium, or it's going to be a third commercial use, which creates the business center and therefore requires a special permit. So from your perspective, I think it is important to find out that use of that third party. Was it represented that Veristag was going to use it? Is Veristag going to use it? Is it going to be used for self-storage? Is it going to be used for something else? Because if it is used for a third use, it becomes a business center, which requires a special permit application. Laurie, the last thing I was going to say is you showed some documents to the commission. Can you submit that? You showed some pictures, right?
Yeah, they have it in their
They have
packet.
this one? All right.
Yes, everything is in their packet.
Okay.
And you know what, one more thing I want to say with these buildings. Did you know in the history of Bethany, none of these metal storage buildings were inspected by our fire department, by our fire inspector? Nothing, our fire marshal. Every single metal building that we have in Bethany, our fire marshal has never, ever touched. And that is disgusting. I think that's disgusting. And if it wasn't for me walking into Sosa's office and saying, hey, can I see Bill Grieger's fire report? Ah, Billy, yeah, his stuff doesn't get, I don't look at his stuff. So that tells you right there. I mean, it's a shame. It's a shame. So thank God that I looked at that, and thank God we have protected buildings now in Bethany.
Yeah,
Anyone have any questions?
Just to complete the record, here's copies of the minutes from the Planning and Zoning Commission from November 5th. Here's a copy of your zoning regulations, I'm sure they're part of the record anyway, with the definition of what a business center is. And finally, it's section 6 of the zoning regulations, which discusses the permitted uses and also the uses which require a special permit in the B&I zone.
Okay.
Thank you.
Thank you.
One more quick thing. This is the email I sent to Carol Goldberg about the Versteeds, my little conversation with the Versteeds. A few days later, we got this in our mailbox, a letter from a concerned Bethany resident.
And Lori, why don't you submit that as part of the record as well? So just so we're clear as to what it is, this is an email from Lori Marenko to Carol Goldberg dated January 14th of 2026. It also includes a letter from a concerned Bethany resident dated November 19th of 2025.
Let me ask you this concerned resident, is they about the property?
I don't know who it is, it just says a concerned resident.
They didn't sign it?
I submitted it as part of the record, so.
Would anyone else like to speak? Public hearing.
Yes, good evening, congratulations. Best wishes. For the record, my name is Ned Fitzpatrick, I'm an attorney in Norfolk, Connecticut, with our firm, and with me is attorney Lauren Geary also with our office. I'm here representing the property owner with regard to this application. I've listened pretty intently to the presentations that were made, council. And also the comments by the Ms. Marenko. I usually don't like to discuss quite the legal matters with the commission, but because you have counsel here who will advise you, I'm sure appropriately. But I would say every matter that was mentioned by counsel along with Ms. Marenko deals with matters that should have been covered, should be covered, and are in fact covered by 8-8, which is 8-8, and furthermore by 8-7D, which is the automatic approval by P&Z. Every one of the issues from bonding to drainage to excavation to runoff to wetlands issues, those are all matters that are deemed concluded and complete pursuant to 8-7D of the general statutes. And there's Supreme Court cases right on point. I'm sure counsel will locate them, or I'm sure he knows what they are. So in the commission, P&Z, your planning and zoning, is the sole determiner of what your regulations mean. They determine whether or not the business park definition applied here. They didn't do that. They decided it didn't. It's likely because it wasn't coming in as a 3-building park. This was a separate building of 2 parcels, and the other 2 buildings are already on the property. The other issue is that this business about the tenant, and it's not that tenant, so the zoning officer made a mistake or it shouldn't apply because there was some kind of misrepresentation. Our Supreme Court has held, and again, I don't like to do this, but I have to because who the tenant is under the Reed case is irrelevant in zoning. Who your tenant is doesn't matter. It's totally irrelevant under Reed, and I'm sure counsel's aware of that case. I've cited that case in several briefs the last 2 years. But that case says that the name of a tenant or who the tenant is not relevant. The use was approved because automatically by operation of law, and that's the Viking case, that says that once you apply for a site plan, it's not acted upon within the appropriate statutory timeframes, it becomes an automatic approval. And what that also means, and the Viking case says this, is that all the approvals and everything associated with that is approved. So that goes with all the issues. That is an automatic approval. That's what they have. This appeal really is all about 8-8. This is an appeal that should be in the Superior Court. Everything they're arguing are matters associated with the substance of a site plan. That belongs in Superior Court under 8-8. And they've done that. That case is pending. it's not within the purview of this commission, and I'm not sure what the experiences of the individual members here, but it's probably it's probably not unusual for you, or probably very unusual for you, actually, to hear this type of an appeal to your board, because the statute says that you're here to hear an appeal from a decision of a zoning enforcement officer. Well, what did the zoning enforcement officer do here? There was an automatic approval by state law. The zoning officer knew that, so the zoning officer issued an approval of the excavation permit and the application for grading, I believe. Excavation and the excavation permit, I believe, is what was foundation and construction permit. So they didn't have the zoning officer didn't have a choice here, because the P&Z didn't act. It's almost as if the P&Z had approved everything. So once it's approved, the zoning officer is required. There's no discretion in the zoning officer here. Zoning officer did nothing wrong. Nothing at all. And all the matters that they're referring to, as I mentioned, all don't belong properly before your board. So you've never probably had to hear this type of a substance in the hearing before you before, because it's inappropriate. You don't have the jurisdiction to decide on bonding and wetlands and soil and excavation, and whether or not the permit was right, and whether the interpretation that P&Z did was correct. That's not your purview. Your purview is to review what the zoning officer did. And the zoning officer acted because the P&Z approval was absolutely perfect, because the operation of the law kicked in. It was not voted on within the time frame. And the cases are pretty clear. And I'm confident your lawyer will advise you directly. Now, having said all that, my clients are here, the principals of the owner are here, and they're anxious as all heck to come and express themselves to the false claims and the inaccuracies and the ridiculous comments made by some of the property owner, who, by the way, is not even in a butter. The property owner came up here, lives far away from this piece. So she is not an aggrieved party to this matter if it goes to another level. But if you'd like to make some comments, having said that, I'd like to hear if there's any questions. I'll take them, but I know my clients still want to address you, because they'd like to address some specifics, even though I've already said to you that everything that's been presented to you doesn't belong in front of you. It belongs in the Superior Court. And secondly, that the zoning officer acted properly, because the P&Z, by operation of law, everything was approved by them. With that, Mr. Grieger or Wendy, whoever, which one you would like to address?
I'm Bill Grieger.
Wendy Grieger.
Evan Grieger, 285 Third Road.
I'd just like to start, to show you the site. The plan that was approved, it's all established. There wasn't much cuts and fills on this because 90% of the building went in the parking lot. This is all.
Can you just describe for the record
Okay.
what you're?
This is looking from Russell Road, and if you look at the blueprint, I'll show you the contours, what was approved. Everything is right to what the plan was approved. And it's all established. The wetlands were called a couple weeks ago. The wetlands enforcer went up there. Everything is exactly was, nothing in the wetlands, because there was allocation that we filled the wetlands. This place, was I'll show you in the blueprint, was 90% of the building went in the existing parking lot. So this is all set now. This is looking down, their driveway's over here. We're way away from the driveway. It's at less than a 2-to-1 slope with the requirements of zoning. This is all done. We're gonna do the plantings that 3 or 4 times their attorney wanted more added. We added them, the engineer, John Paul Garcia. This is all level right now all we have to do is trench 42 inches down, pour the foundation. Site work's done. Septic was put in over a year ago, and they kept bringing it up saying it wasn't approved. What the mention was about 5 people, it's for this building, not for the whole facility. and it's all approved by Quinnipiac Valley Health, tested and so forth. And on top of the drainage, John Paul did the drainage. It's all approved by the town engineer for the site, and all that's been done, and it just took over a year going back and forth, because once they kept one of the things added and they wouldn't let John Paul know the day of the meeting, it would kick it out another month, kick it out another month. So the site work is done. There's no more fill coming on. All there'll be is maybe a load of stone to fine tune the slab. Septic is installed, the well is coming off from the water that's there. It's all milled and everything. And I don't know if the zoning official's been up on the property. They're more than welcome to. The wetlands, there's a letter in there saying that it was done. And then the town planner required John Paul to go up, and I don't know if he went with them, and John Paul went and reviewed it when they said we filled the wetlands, and said everything is exactly to the blueprint, no wetlands were filled and so forth. A lot of misallocations go on with this, and I've been in town for almost 50 years.
There's been a letter submitted from John Paul Garcia for a site plan visit with pictures. He gave a summary of his visit when we got allegations of we were filling the wetlands.
And those were submitted to P and Z?
They're in the records.
They're in the record.
In P and Z, the P and Z record, okay.
Yeah.
Just not, you haven't submitted them.
I mean,
for
I
this
could show
tonight.
them to you.
No, I'm just asking
Okay,
just
yep.
for clarity.
And Ms. First Selectman, she had the letters and read it to us, because I went and saw her personally. I said, do you want to go up there? We take pride in what we do. The other thing regarding the fire marshal, I own quite a few buildings in town, and we make them nicer than required. Like the one next to the state police barracks, we put a white fence up. We make them look like a house. We put double hung windows, we put vinyl siding. They keep calling these metal giants. I don't know how long everybody's been in town, I think many years. On Fairwood Road, that was the most hazardous building in Connecticut. It was one of the top two. The old chemical company. We leveled that building, and the planning and zoning people at the time, I brought a picture and said, we're gonna make it look like this. I was raking my lawn, she goes, you did more than everybody says. The building's on, you look like a house. And they keep saying we're doing a mental giant. We're doing a wooden building, double hung siding, and then right on the other side of the driveway, the house that they said that had small kids are gonna be out there. The husband is a detective, he's gonna come there. They said he has no issue with it. And I said to him, was there anything, she goes, we have no issue. We bought this property 5 years ago, it's been quiet, no problems. She said, can you put in the tall green giants? I said, sure. So they have, and there's, I think, someone from the other side of the property here have no issues. But the drainage has been all approved with the town engineer. We have all the permits in order. The septic's in, the site work's done except for a half a day digging trenches. Concrete does it, we pour it. And like I said, this is a wooden building. And the fire marshal's been in every single building we own. And there's a letter from the fire marshal that all the evacuation people are living there, there's hazardous stuff going on. And it's a
There
whole
was
report.
lots of pictures that were shown to you. Those pictures were maybe back 20 years ago. There's not even anything of current. And one of the renters there was approached by the Marenkos. Prestige did not approach her.
That's
She
not
was
true.
approached on the road when she was walking her dog. She said that she approached her and tried to befriend her and say, oh, nice dog, oh, what a nice dog, and then got into the conversation about, the application.
And to say about the application, the Prestige, we started like over a year and a half ago on this project. We asked them, they said, yes, we'd be interested in it. We put their name on the application, okay? After all this, and I can't blame them, she's afraid of being sued. So we said, no problem. There's 2 other tenants in the building. We have letters from them. They'll take the building. They've been in that building, the building's been built in the 70s. 2 other tenants have no problem taking it. And whoever's going in there is going to be a business and go in front of zoning. Prestige, when the building's done and CO'd, if they do not want the building, there's no obligation to that. But the other 2 tenants will take it that are on that building. So the issue of saying we're falsifying the record, I take things to heart on it. And like I said, everybody, has been happy, no complaints on it, and it's just unbelievable. I mean, she had the Prestige people, I feel so fired for their company. She had her subpoenaed. A sheriff went and subpoenaed her to come to a hearing like this. That's crazy. This isn't a court of law.
Stating that
And
they
she was
were
so upset.
washing metals into that is not true. They are the most environmentally friendly people you want going. Emily Vestige said, my father would be rolling over in his grave right now. He was the most environmentally friendly guy. He would never be doing anything to harm wetlands or anything, and we're not even anywhere near the wetlands.
It's 180 feet out of the review area. And where the parking lot and so forth is, it's the same amount of parking. We just basically leveled out and put in for the pad. And all these slopes in there on the blueprint, what was approved was zoning, and the amount of material moved there was hardly anything.
These buildings have been there. The first one was built in
75.
I'm sorry. The first building, when the Sweets owned the property, 75, and then they put the other building in on 85. They did, a little bit at a time. I just want to notate also that this whole area, a piece of property, the Sweets changed over from B&I to an R65 zone. And that's the piece of the property that the Marenkos bought. So they bought knowing that it was a B&I zone, and then they changed it over to a residential use, which is fine.
And the artists were there.
But they were already there.
Yeah, the artists were there when they built their house.
That was changed in 2002. The Marenkos purchased their property 2004. So these buildings were there from 1975. This wasn't anything new. None of these changes have, most of the people that are in there were in there when the Sweets owned the property. We've just bought the property from the Sweets with the current tenants in there. These are the same people that have been in there for years. Nobody ever made this kind of stink about this. Is it just the Griegers? Yes, it is, the Griegers.
And if you look, we have their property.
We have a
is
stellar record in
600
town.
feet behind this building. You have the map, the lady that she said her kids are gonna be out there, she had no problem at all.
We talked to
She
her,
was
we
very
talked to her on the
nice.
phone tonight.
They were gonna come, but her husband,
I wish that she did come.
And
I
she
could
said-
ask her to send a letter. She was very nice. Bill approached her and he said, could I talk to you? She said, yes. She said, I have no problem with your building. We always said, if you ever have a problem with noise or anything that you see that's not right, if you can't get a hold of us, call the police. I don't have a problem. I don't want somebody doing something that's not legal, correct, or bothering any of the neighbors. I asked another neighbor abutting. Okay, Leslie lives right in the back of this property. For the record, Leslie, can you stand and if you have anything to say?
So I am,
Can you just say your full name?
yes,
and
Leslie
address?
Crone, 35 Russell Road.
Thanks.
We are, how would you say, literally the next driveway to
There's them.
the properties. And I have no problem with what's going on here at all.
But don't you have the same type of property? Don't you have like a business in there also?
No.
Yeah, you do.
You're on the other side.
We know
The
you're
building
joking.
isn't next to you, the new building isn't next to you.
It's,
Yeah,
Okay,
don't you get the new building?
But it's not next to you either.
please address
Yes, it is, it's my
You
father's
have-
property.
yeah, I know where your father's property is.
Wait, we can't have, like, talking to.
So it's the same thing.
ZBA, not to each other.
All right, everybody, please address the board.
That's not the fill that was approved.
And if you, we'll give you a chance to speak when you're gonna be up next. Did you have anything else?
Yeah, no, I'm just
Okay.
saying, I have no issue with what's going on. They have been great. It has not been any type of, it hasn't been a problem at all. I just don't understand at all. And I literally live right there. I'm right on 35. There's no problem.
Can I say one thing about the buildings?
Did anyone have any questions for either of the two parties that just spoke?
I just wanted to show you, you were saying about buffering and all this, just because, it's hard to tell, this,
So for the record, this
Yep.
is a town of Bethany map.
we're sitting, this would be the road,
There's
okay,
Russell Road.
all right. These are the buildings up there, the other one's here.
This is the
Yeah.
current one that's
All
going
right,
in.
the Marenko's property is way back there. This is all wetlands and so forth, so you don't need to screen, it's natural buffer, you can't see in there for anything. It's highly vegetation, which could not be disturbed or anything, it's not even on our property. Really, the wetlands is off our property, only a little piece way away from it. The lady over here that her husband's a detective in New Haven, they're looking right at the building, they have no issue. And then,
The Carones live
right here, they have a
This is-
driveway on the other
They
side.
abut us on this side.
So, just so you see how it's situated on the property, it sits up on a hill on it.
There is no tractor trailers
There's
that
no
come
one.
in and out of there.
Yeah,
There is,
never.
the lower buildings, there's like one or two people that work in these shops. There's not a lot of people that are in and out. This is not retail. This is a guy that owns like custom sheet metal. He has him and somebody else that works for him.
We could,
Right, okay, gotcha.
if you could, any comments, please address the board when it's your time, when it's your turn. It's a lot of information to intake, we want to give everybody a chance to talk.
But I just wanted you to see how it lays out, so if you saw the pictures, it's all like, what you saw.
I mean, this is B&I zone. We did what we were asked to do. We met the requirements month after month, these meetings. Could we do this? Can we didn't address this. We addressed all the issues. We addressed everything,
Yeah.
all the requirements.
Did anyone have any questions for the Griegers?
Because I don't even know if this is.
And this is not a
that
metal
job, because we did, for humanity,
You want the approval for the town?
we did a house on Bear Hill Road. We hauled some materials, so I don't know what's from there. There's that new house for that handicapped gentleman who donated some time. So, I mean, I don't know, but it doesn't, you can't see the building in the background, you see the building. Like in our pictures, when we the photos, you see the building. So, whatever. But if you want to see the blueprint, if you have any questions about the filling and so forth, it's all out. It was existing contours. There wasn't very much disturbance, whatever. And this is from Quinnipiac. Everything's approved of the system for the five people.
For the record, this is,
Yeah, you can-
is this from KVHD?
Yeah, see it stamped and everything. And like the septic's in, everything, the site work's basically 100% done. Except for, fine tuning after the foundation's been poured on it. And then as soon as the weather breaks, the landscaping to what was approved per their lawyer, what wanted out on the plan. And at the night of the meeting, when they didn't have enough people to vote, the commission said everything was fine. And if you look in the record, a couple of the people on the board said, it's met all the
This
requirements for
should
the
be
town.
approval. This should be approved. It's right in the meeting minutes. There's more than one, official on the board that said, there's no reason why this should not be approved.
And we went I've built many buildings, we do what the town requires, we did everything required, went to every meeting, did everything. And then talking to the town attorney before the new attorney, he said, everything met, you're 100%. And he even said about, that building, when it was approved, it was before the moratorium, but we're having, one of the tenants are gonna go in there. Or it's gonna be a commercial person that goes in front of zoning. You just can't go in there, it has to be, and it's just when that the lady wanted it, and then I don't blame her. She's suing everybody, in the town, suing the first selectman. It's crazy, but thank you for listening.
All right,
Yep, thank you.
did you have any more?
Just one quick, so I appreciate your patience, all of you, this is, but I wanted them to at least give you the substance of what's happened here, so you're not looking at a vacuum, even though I've already said to you that it's largely irrelevant. This is all a planning and zoning issue, it's not a ZBA issue. All these issues go under 8-8 and will be determined by the Superior Court. But I wanted you to understand that they're not trying to skirt anything or do anything underhanded, that they have the appropriate approvals, you've seen them, you've heard them, and that they're doing everything the right way. So notwithstanding the fact that I said those matters don't apply, I just thought it was helpful that you hear the flavor. Thank you.
Thank you. Would anyone else like to speak?
I would speak at this moment, but after you're done going to public, we would like to have an opportunity just to address the commission in the ball.
I'm sorry, after when?
After you finish going to the public
Okay.
comment, we would like an opportunity to address the commission for the ball.
Yes, I want to talk about the buildings.
Can you just
Let
state?
them finish with the public comment.
One thing just to say,
Oh, wait.
for the record, it'll be here. Yeah, one thing. The Marenkos having a permit for a big metal building on Route 63. So they keep saying these mental giants and so forth, they gotta knock down a mountain of rock. They have building approvals, I have no problem with it. But saying all these bad buildings in town, ask them.
They're doing the same.
They have the permits for it.
That's not Robert Senior, that's me.
Okay.
And we
Well,
had that up for sale. We had that land for sale.
all right, you have to please address any comments to the board. Does anyone else have any other comments from the public? Oh, sorry. Forgot. Stephanie?
Hi, this is Stephanie Wild. I am the family that has been talked about with the 3 little kids.
Can you
And
state your address?
yep, so we're on 61 Russell Road.
Thank you.
Yep. And so I just wanted to just so our position, everything that Mr. Grieger said is correct. When we spoke about the property and what he was doing over there, I just, we mainly talked about privacy and how he was going to put up some tree line there so we can, maintain that privacy that we had before, which is great. What I didn't know was the wetland concerns that our neighbors brought to the table, and so that's something that I just wanted to put out there, that because I feel like we're being used a little bit as a pawn on both sides of the argument here, and so I feel that I would have loved to have that information as well ahead of time, and that's all. Thank you.
Thank you. Are there any other comments from the public at this time?
I'll be, Timothy Lee on behalf of the appellant, I'll be very brief. Just to address a couple of issues, and as was referenced, it may come down to an opinion from the town attorney. But we have appealed a decision from the zoning enforcement officer. That decision was to issue the administrative permit for this property. So that was an action of the zoning enforcement officer. We are entitled to appeal that decision. We've appealed it to the zoning board of appeals. You are the appropriate entity to hear the appeal of that decision. So I think we're here tonight in the right venue with the right appeal, and you've heard the evidence regarding that. With regard to the issue of whether the activity that's going on the site now is subsumed within the so-called automatic approval, as I said in my statement, if the application required a site plan, they didn't act upon it, there is the theory that they're entitled to automatic approval. We've appealed that to the court. We'll let the court decide that. But there's more to this case than that. You can get automatic approval or inferred approval on a site plan application. You can't get automatic or inferred approval if the activity requires a special permit. So in this case, it's our position that this activity required a special permit for fill and excavation, because there's more than 500 square feet of activity, earth removal activity. And 2, it's a business center park, and that requires a special permit under your regulations. Since those are special permit uses, they're not subject to the automatic approval. Now I'll turn it over to Lori.
Okay, so when I talk about the buildings, I'm not a novice with those buildings. What they don't know is we have first right of refusal on those properties. So Gale Sweet showed us those properties before they bought it, and we said, no, we don't want to buy those buildings because they were so decrepit, they were so old, we didn't want anything to do with them. I've been inside those buildings and outside of those buildings. I've been up and down that land, up and down, left and right. I know that property like the back of my hand because, as I said, Gale Sweet offered that to us first, and we said no. So that's what they don't know about it. So when I talk about it, I'm not talking out of a novice. Second, they mentioned violations. She mentioned, oh, we have a stellar reputation in town. They have people living in their storage buildings, and this, God help me, should be the last time I voice this in this room. I have been voicing that every goddamn month for the past year. So I don't want him putting up a building in my father-in-law's driveway where we're gonna have people living there, because that's what they have now. They have people living there. Number 2, okay, I have to calm down. I gotta calm down a little. They have violations all throughout town. On Hamilton Drive, Mr. Grieger, I witnessed him taking millings and filling in the wetlands with millings because he wanted his parking lot bigger. If you look, I'm sure our CEO, Lena Frazier, looked into it. It was discussed at an inland wetland meeting. He decided to put millings in the inland wetlands. That is a clear violation and he should have been charged for that. That's one. Number two, I think it's Pleasant Drive. No gas, no, wait a minute, no auto repair. There's been auto repair shops there left and right. He's got violations. I have a full list and I will take it up with our CEO when that system comes up and running. So don't look at them, oh, we're stellar, we have a great reputation, because they do not. And as far as being the abutting neighbor, that is my in-law's driveway. I am here on behalf of my father-in-law and my mother-in-law who are sick, and I represent them wholeheartedly. So that abutting neighbor garbage does not apply.
And my final point is, I did subpoena the Verstags to attend the meeting tonight because my client had a conversation with the Verstags in which they said, if you wish your subpoena, we will come and we will testify. I see that Ms. Verstag is on the Zoom call tonight. If the commission has any questions or think her testimony is relevant to your determination, I would ask her to, or you would ask her to speak if you think that she has got evidence that's relevant to tonight's proceedings.
I think you have her statement. I'm not convinced of the relevance of the Verstag. You have the statement.
Okay, so we already have a statement.
This is not about tenancy, this is about use.
Okay. All right, I think we're set then. Thank you.
You know, excuse me, one thing about Hamilton, have a look at the record. He had to put the septic system when he rebuilt it. It was from Quinnipiac. They put a complaint in the wetlands. The wetlands went in front of them, they asked me to have the wetlands flag. It went into where the original system was put in back 25 years ago. Wetlands went out there, had a meeting, everything is fine, 100%. Look in the folder, they just don't like saying things that are untrue. Ask the what Christine Sullivan, one of the gentlemen on the committee went out there, they went through it, checked everything fine. So we didn't fill wetlands. We moved the millings, replaced the system, put it back. In one day, it was inspected by the health department and the wetlands was out there. And there's no complaint, there's no anything that we're getting, everything's exact, no violation. So that is untrue if you'd like to look into that.
Correct. Are there any other comments
And
about
just for the
this
record,
specific?
the fire
property?
marshal walked each and every unit that we own. I have letters from the fire marshal. No, there's no issues.
There's nobody living in the building.
There's no problems. I have letters from the fire marshal, if the board would like that.
Okay.
If you'd like to put those letters in the record, now would be a good time to do
How
that.
many do you have there? Do you have a note from you? Oh, yeah, one. Did he do it on the
The only thing is, I kinda want a copy of these. These are the originals. There's a,
copy.
Do we have this many?
Yeah.
there's a letter for each building.
Why
That
don't you put the copies into the record, not the.
I think I did send them to Laura.
We have a set, we can, I just wanna make sure they weren't lost or misplaced. So these are the copies of the fire marshal approval letters with respect to all properties. And the only reason, of course, we bring this is because of the claim being made by this.
That's been entered into record. Thanks.
Don't need it, it's 10.
All right. Does anyone that hasn't spoken wish to speak on behalf of this or on this issue for this appeal? Hearing no further requests, should I close? Okay.
Does everybody have everything in the record they wanna put in the record? Because after tonight, you can't put it in the record. Then you can.
Okay. So we will now, do we make a motion to close?
Yes.
Okay, so do I hear a motion to close the public hearing portion?
Robert Huxley.
All right, Cynthia moved, seconded by Robert.
Yeah.
All in favor, say aye.
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 8:30.
All right. Public hearing closes at 8:30.
Mr. Chairman, I'd
Yes.
just like to, I'm Bob DiCrescenzo, I'm the town attorney since January 1st. There's a lot here. What I would recommend, and just to frame the issue, what you have before you tonight is the appeal of a decision of the zoning enforcement officer to issue, let me get the title of the document, it's been talked about a lot, an administrative zoning permit. It was signed on November 19th, 2025, and based on that, the owner received a building permit. What's been put in front of you is a claim that that administrative zoning permit was issued in error because not all required approvals were in place. And the administrative zoning permit is a certification essentially by the owner that all required approvals have been obtained. And then the town official signs the administrative zoning permit, which is then used to apply for a building permit. What's been challenged is whether or not essentially all required zoning approvals had been obtained. So that's what's in front of you tonight. And I would recommend that you not act tonight, but you ask for a staff report that sort of synthesizes all this evidence and documents and reports back to you with some findings based on the record for you to act on this application. I think there's too much here to distill and use as a basis of an action tonight. Because there's been a lot of allegations and they sort of set each other off a bit. And I think you need some assistance from staff to sort through all that.
Okay. Do we need to make a motion on that, or can we just accept that recommendation and set up?
Well, I think you should move to request a staff permit that considers all, staff report that considers all of the evidence and documents you received tonight and report back no later than your next meeting.
Okay.
And then you can.
I'll make a motion for that staff report.
I'll second.
Seconded by Nick. All in favor, say aye.
Aye.
Nay? Okay, motion passes. So we will have that report, the staff report, and use that to inform our deliberations.
Consider an act on the application.
Yeah, to consider an act on the application. And that will be submitted to us before the next scheduled meeting. I don't believe there was any other business on our agenda, so if anybody has a motion to adjourn.
Well, that's Nick's favorite thing.
That's my favorite thing.
Oh, okay, I'm sorry.
Cynthia and Nick, all in favor? Aye.
Aye.
Meeting you go to. It is, yeah. Hey, it's gotta be something, somebody's gotta do it.
Would you like to make copies?
Amazing. Okay, yeah.
That way I don't have, I'll keep one copy of the file.
So much paper.
Yeah, just.
You do.